Hi, everyone. Welcome to the webinar. My name is Sarah, and I'm going to be acting as a host slash moderator today. I am here with attorney Erin Mullen, and she is going to discuss with us the basics of mandatory financial disclosures. She is just a wealth of knowledge. We are so lucky to have her with us at Johnson Law Group, and even more happy to have her with us here today to share some of that knowledge with everyone. As a reminder, there will be time for questions and answers at the end of the webinar. So feel free to type in any questions that you have during the webinar into the chat box, and I will read those out to Erin at the end of the webinar. As always, your participation, questions, and attendance is entirely anonymous, and we hope that you enjoy the webinar. Erin, I'm going to go ahead and pass it over to you.
Thank you, Sarah. And hi, good afternoon. So I am seeing, Sarah, it says I am the host now. I don't see where I have to take over the control. So are we good to go?
Yep, all you have to do is press share screen and you are set.
Okay, excellent. All right, so good afternoon. As Sarah said, my name is Erin Mullen and I am an associate attorney here with Johnson Law Group. What we are going to discuss today are our mandatory financial disclosures, which are a really challenging part of the dissolution of marriage process and also the allocation of parental responsibility process if there are child support issues at play. Even attorney fees issues can relate to these mandatory financial disclosures. So it's very important that we get them right. So I'm going to share my screen with you. Our firm has put together a really nice packet that provides our clients with a general view of what is going to be expected of you from these mandatory financial disclosures. Now, these are governed by the Code of Civil Procedure, Article 16.2. They are, as the name suggests, mandatory. And what they do for you is that they make certain, when we provide these accurately and thoroughly, that you have a full picture of all of your financial issues. Parties sometimes, and I'm lucky to work with very honest clients for the most part, and really always, parties sometimes want to keep certain financial information private. And by private, I mean they do not necessarily want to share that with the person who they've been engaging in a contentious situation with. So this is most frequent in a divorce or dissolution of marriage proceeding, but it also comes up in child support proceedings. It is natural to feel like this is my money and I shouldn't have to tell anyone about it, about where it came from, about where it's going. This is private. The Colorado legislature has created this framework for us to use because they want full transparency of financial issues. This is designed to protect both parties from having anything spring up after the dissolution that could then harm you financially. You don't want a debt lingering out there that you are unaware of that your spouse may have incurred in both of your names. At the same time, you don't want assets sitting out there. Neither party wants to find out after their dissolution is finished that there is a large sum of money that is in existence and that they would have had access to had they just been informed prior to the resolution of the matter. And so for those reasons, it is very important that we provide full and thorough mandatory financial disclosures. I want to, of course, let you know that this is not legal advice, that there is no attorney-client presentation from this discussion today, from your attendance or your observation of this webinar, but I am glad to have you with me today. And I think that this is such a vital part of the process, and it's a difficult part of the process. And so it is especially important to me for clients to understand what's coming up and that this is something that they will need to anticipate as their case progresses. And I will tell you, if you speak with an attorney who tells you that this is an easy part of the process, I would question that, because it's not always easy to obtain your documents. Now, in the days of the internet and the computer being very accessible, the internet being very accessible, it's a lot easier than it once was. But even still, not every financial entity that you work with is going to have all of their processes and statements uploaded into a digital format. So there are times when you will have to seek a physical statement, but frequently, if you are going through the process of mandatory financial disclosures, then your first point of action should be to make certain that you have a digital account for all of your financial institutions, and that you have access to your password for that digital account, and that you know how to log on, how to search or navigate that website in order to obtain any statements that you might be seeking. I have found that with some financial institutions, in order to obtain digital statements, you would have to relinquish receiving physical statements. So there are some banks that will say you have an option. You either opt out of receiving physical statements, or you only receive physical statements, and that's fine. It's your choice on how you want to proceed in that way. But if you are only receiving physical statements, then beginning now, you need to be keeping a file with those physical statements. And I would suggest that you hang on to your financial documents for probably a period of 3 years. It is cumbersome, it is voluminous at times, but you will be grateful that you have kept those documents when your dissolution occurs, when your child support issues stem. You'll be grateful to have those. So what our PowerPoint is going to tell you here is that the mandatory financial disclosures are often, they're not the first step in your dissolution proceeding or your custody case, but they could be. So when I say that, what I mean is that you can begin gathering your documents before you file your petition. There is nothing that would stop you from doing that. You are going to have to provide months of statements. And generally speaking, with your financial disclosures, you are going to provide the most recent 3 months of statements initially, but then you're going to need to update those as your case progresses. And so if your dissolution case is pending for a year and a half, which of course we would hope that that's not the case, but sometimes it does happen that for various reasons you have a case that lasts a long time, you're going to need to continually update those financial disclosures. And as different financial events occur in your life, you're going to need to provide the opposing party with those updates. So generally speaking, we file the disclosures, and those are the supporting documents for the sworn financial statement that we will provide to the opposing party and file with the court. The disclosures themselves are not filed with the court. What we actually do is we file a document that is called a certification of compliance with Code of Civil Procedure Article 16.2 regarding those mandatory financial disclosures. And that document is going to tell the court that we have complied with this requirement, and often the attorney will then list the particular portions that they have complied with. So this certificate or certification, which you will sign and verify, so it acts as a sworn statement, might state that you've provided 3 months of bank records or 3 months of credit card statements. If it's something that you're updating and your attorney chooses to file a certification of compliance every time you update those statements, which they're not required to do, but they might, it is certainly not, it's one of those decisions that is really based a lot upon your case strategy and your relationship with your the party from whom you're separating, divorcing, or seeking child custody. And as you go on, if you're filing these certificates with the updated disclosures, then your attorney will also list what you're providing in that interim period. So the number of statements for any one type of financial issue could vary. It could be you might update them in a 6-month period and just provide all 6 months that have occurred in the meanwhile. That's really up to you and your attorney. What you need to be sure is that you are updating them. So we're going to start, this section discusses the steps. So your attorney will generally provide you with a list of the items that you need to disclose. And those will relate to the type of hearing that you are looking toward. And they will in part depend on your own financial picture. Obviously, if the statute and the law requires that you provide any documents related to a loan that you've taken and you have not taken any loans, then you do not have to provide evidence that you have not done something. So what we will often do is take the general list of mandatory financial disclosures and then compare them to our client's financial picture. And so if certain things are not going to be relevant toward the case, or if we know our client does not have these items, then we will say to them, you know, do you have a car loan? If you don't have a car loan, then obviously we do not need you to try to come up with a statement that says, I do not have a car loan, I have no debt for my vehicle. So we really want you to be careful with this and cautious with this. Err on the side of disclosure. One of the problems when parties do not fully disclose is that the certainty that you have from a court order that divides your property or sets your child support amount can be upset by figures that were not disclosed initially. And by that, you might think, I've moved on with my life. I am divorced. I have now purchased a home. I have taken on other debts. I have purchased assets. And suddenly your ex-spouse might say, well, I just discovered this undisclosed document and I want to bring this back to court and I want to reopen this property agreement, or I want the court to reconsider this order. And there is a term of 5 years after this dissolution is complete where the court could do that. They can only do that if you have not disclosed your financial information. So it's very important that we provide that fully and thoroughly, as I said before. So as the attorney, one of the things that I do is as we compile your sworn financial statement and we have all of these supporting documents that you've sent us with your mandatory financial disclosures, then I go through and I verify that the information contained in your sworn financial statement is supported by those documents that you've provided us. That also gives me an opportunity to inventory the documents. Oftentimes, dissolution of marriage is a stressful period of time in people's lives. Child support issues, which are of course related to the allocation of parental responsibilities, these are stressful times. It's frequent that the last thing that you or your spouse or ex-spouse or ex-partner or whatever that relationship is with the other parent of your children, you really don't want to look at it. You might not want to examine your life in that much detail. I can assure you that you will be very grateful that you did. And further, you will probably have the best overview of your true financial picture that you've ever had, that barring you having an accountant, a personal accountant who can provide you with a full inventory of all of your financial assets and debts and present those to you in a really clear and clean way. This is the opportunity to have that. And it's especially helpful for you on a personal level because after this process is over, either of these processes, the parental responsibility or the dissolution of marriage process, you are going to be in a position where you're going to need to make a lot of important financial decisions. And having a really good, clear, and detailed picture of where you are financially will benefit you greatly as you go forward and make those financial decisions. Excuse me, I'm gonna grab a sip of water. The other thing we do when we go through as the attorney is the financial disclosures from our clients. Or we're going to, as I say, inventory, and inventory will include noting what we still need to obtain. And because it is such a stressful time, it's very easy for you to overlook certain documents, and that's okay. We are certainly not judging you for that part of the process at all, or for any part of the process, but we understand that it's tough, and that when you're sorting through any number of documents and you're trying to collate them and you're trying to include everything you need to include, then you overlook things. And so we are going to be reminding you regularly that we've received your financial disclosures. We thank you. We are still missing this credit card statement for the month of April, whatever month it may be. So we don't do that to hound you or to bother you. We do that because we are engaged in the process of protecting you, protecting your assets, protecting you as a party who is going through a lot of change. And so in order to protect you and to forward your expectations for the case, then we need to have that full picture. The benefit of having those from the opposing party is also evident. I think most people would agree they would be much more comfortable receiving all of their spouse or soon to be ex-spouse's financial documents than they are providing their own. And clients often will review those documents alongside with me. So we to the extent that we are required, we provide all of these documents to our clients, and they have the ability to kind of comb through and see if something raises a red flag to them. So for example, when we are looking at the opposing party's financial disclosures, if we're looking at their bank statements, then we're going to be looking for large withdrawals. Where are those going? Into what account are they going? We're not going to have the account number, but it is often helpful if we are seeing repeated withdrawals. If there are particular issues in your case that are of our concern, then we might be noting the nature of where payments are going. So are they spending hundreds of dollars on groceries versus are they spending hundreds of dollars at the liquor store? And this isn't necessarily important in your case. And it doesn't mean that finding that an adult is purchasing items that are perfectly legal and available for an adult to purchase is going to create any kind of inference or concern. It's just that we are able to examine these documents and see if there are any patterns that are concerning. And if they are, sometimes those patterns in and of themselves don't mean much, but it gives us a basis for exploration of that pattern. So because these are due 42 days after the inception of the case, it allows us to have an idea if we need to explore further before our discovery deadline has passed. And so we can take that knowledge if we have found a variety of purchases from, say, a particular vendor, and we don't know who or what that vendor is. Well, we have time to research it ourselves, and we also have time, if it's necessary, to ask that question in an interrogatory if we need to. Just specifically state, please explain to us the business that is entitled Treehouse LLC. So it's a very productive process in many ways. Another thing that is uncomfortable for clients, but that is very important and that really helps us is also credit card statements. Again, just seeing where your money is spent, seeing where their money is spent. And it helps us as your attorney, because if we see something in your own statements or in your credit card or your bank statements that we suspect might trigger the other party to look into, then we have time to prepare our explanation. If this is an innocuous purchase, then we have time to gather that information so that we can provide that. Or if they don't bring it up to us before, if they bring it up in court, we have at least some advance warning of potential issues. And I do find that very helpful. Also, it gives us time to address issues if there are actual issues out there. Say your financial documents were to demonstrate that you spend hundreds of dollars on alcohol daily. That might be completely innocuous. It may be that you are purchasing alcohol for gifts or as a part of a marketing strategy for a business. There could be a variety of reasons. It could be business related or nonetheless, if it's not, it gives us a chance to ask and say, hey, so we're noticing this. I suspect that when they receive these, then they are going to be concerned about this. Can you tell me what's going on here? And if the client says, well, I drink hundreds of alcohol, I drink all of my purchases every day, or something to that effect, then we can start talking about what we need to do to prepare them going forward. And it might be, alcohol is just an example of many potential issues, but if our client has, if this reveals something that looks like it could be an alcohol issue, then it might be strategically smart for us to get them into a program at that point, or for us to advise, shouldn't say get them into anything, to advise our client that it would be strategically beneficial for you to start addressing this through some professional means, so that if they do bring it up down the line in 2 months, 3 months, when we have a hearing, then we can say, sure, we see you thought you had a gotcha moment, but in fact, our client is aware that they have a problem and that they have addressed that problem through professional means. And the court is going to have a lot of admiration for a parent who is seeking treatment for any issue. And it's going to create an entirely different dynamic than if the court is to believe that there is an issue and it hasn't been addressed. So that is a way that these can help us be productive. Excuse me for one moment. My allergies are active right now at this time of the year. So this is a copy of a checklist. It's not exactly the checklist that we would give to our client, but it includes the types of things that are going to be required to be provided during mandatory financial disclosures. And so you see, there are a variety of types of documents that can be required. And again, many of these are going to seem very personal, and you are going to feel very exposed, and that's natural. You are not exposed. The documents are confidential. They are not filed into the court record. If for some reason a party does file them into the court record, typically if they are a document that has any nature, any privacy rights attendant to that document, then the court is going to list those documents in their system as being suppressed, so that only parties are able to view those documents and not the general public if they were to inquire. Now, when you're looking at this document, you're going to see things like, as you see, medical invoices. Again, those are documents that are very personal in nature, and they have more than one value. Of course, one part of the value is to see financially where you are, but another part of the value to us as your attorneys and to the opposing counsel or your opposing party is that it does give us some insight into, as we discussed earlier, any issues that might need to be addressed or contemplated. Physical and mental health are one of the factors in the best interest statute. And so for that reason, while we may be bringing in these documents for the purpose of evaluating the financial picture and providing those to the opposing party, we're also always keeping our eyes open for something that could be considered as a factor in another portion of your case. And it's really a luxury to have those items up front. We're much better preparing for an issue in advance than attempting to head it off after a surprise at a hearing. And I think it's very important. All attorneys will tell their clients this, your honesty with your attorney is imperative. It is confidential, it is privileged, but we can't do our jobs for you unless you are forthcoming with us. We will do our best, but it just opens up so many areas of risk for you if you were not fully forthcoming with your attorney. Some of these items that we list here probably seem strange, again, intrusive and strange to people who are not sort of experienced in this process. So things like your employee benefits, you might say, well, how does that relate to the amount of money I have? Well, certain benefits do carry a monetary value. In some places of employment, your time off, your paid leave might be payable at the end of your employment. So it would carry then a monetary value that would be directly related to your hourly rate or your salary. And as I look through life insurance policies, those are really important. And it's important to note that there are different types of life insurance policies out there. There are some policies that you purchase and that you pay on monthly and that never accrue any value that you can access until your death. And then whoever your beneficiary is can access the assets there. There are also life insurance policies that act in a similar fashion to a savings account. And so in those policies, you are actually accruing wealth while you are making your payments. There may be an interest rate reflected there as well. And so it's really important that we know the distinction. Does your life insurance policy have a face value? And when we say face value, we're really discussing the current value of that policy. So if you have been paying into that policy for 20 years and it has a balance of $220,000 that you could access at any time, then we're going to have to disclose that, and we're going to have to talk about how that is divided up, or how it should be divided up, and whether it should be divided up. It's also very important that we know the dates that these policies or accounts were started, particularly with retirement funds. Parties might have started their retirement funds years before they were married. In that case, we want to know the exact date that fund began, and we're also going to want to have a statement that reflects the date of that you entered into your marriage, so that we can see how much of that property would most likely be considered separate property by the courts. The presumption is going to be that property that is obtained during the marriage is going to be marital property. And there are in very few, but in few cases, you could dispute that. But in order to dispute that, you will absolutely have to show why and how that money is not marital property. And in cases of retirement accounts, frequently those will be part separate property and part marital property. And we want to be able to divide that up so that we know what portion of that property you should be able to walk away with free and clear without having to provide that property to the other party. And we'll need to disclose that information as well. We need to disclose to them when that date was. When, generally speaking, when an attorney who is doing their job recognizes that information, that's one other piece of information that you don't have to litigate, because you can usually look at the picture and see when that account might have become marital property. And this is going to be the same issue with other items. So your car, did you buy your car before you were married? Did you buy your car in cash before you were married? Was that car your separate property? Or did you buy your car and pay it off after you were married using funds that were marital property? All of those things matter when dividing up your property. Your paychecks, those are vitally important. And again, people often don't want to provide them, but they give us a wealth of information because they also tell us whether you were placing money in a health savings account, whether you were placing money in a retirement fund, whether you were paying back funds that you borrowed from a retirement fund. A lot of retirement policies will allow you to borrow money from them, but you have to pay them back. And so that debt might be a marital debt. It could be a marital debt on a separate asset. And that gets even more technical, because if you've borrowed money for the marriage from a personal account, then we have to determine whether or not we have a good argument to show that that is still separate property versus marital property. We can't make those arguments unless you are providing us with everything that we ask for. Some of the things that we ask for here will be specifically related to things that you could deduct from child support. So if you're paying for extraordinary expenses for your children, we want to see all of those documents. We will be required to provide some of those documents to opposing counsel or the opposing party. But you still want us to see them, because that is how we assert your right to deduct that amount from a child support allocation. So it's very important that we are able to determine all of those figures, including health insurance. How much are you paying for you? How much are you paying for the children? It really benefits you to make certain that we receive these documents quickly and upfront. And I think one of the things that parties tend to forget is that the way that attorneys charge generally, unless you're dealing with a flat fee case, which is probably in family law is not all that common, then you're going to be charged based upon the communications that your attorneys and that your the support staff and for the law firm are going to be conducting on your behalf. And so if, as your attorney, I have to send you 5 emails asking you for documents, and in order to assess what you have provided me and not provided me, I have to go look back through your file and note everything that is there and isn't there. Or I have to then, open up statements and discover through those statements that there are other accounts out there that I haven't received. Then the time that it takes to do that is all time that you're being charged for. So providing it upfront to your attorney is going to save you a lot of money in the long run. And providing it in a clear and easily reviewed format will also be imperative. Another thing that I have noticed is that because of, I think, the difficulty of searching through networks or systems or databases in order to get, say, a statement downloaded into a PDF form, people will sometimes send me screenshots of items. Screenshots are really not that useful. What we need are statements, and we really want them to be in a Word document or a PDF, in some type of document that we can easily organize, easily label, easily send to the opposing party. The more time the attorney or paralegal has to spend collating, organizing, converting into another document, that's all time you're spending on your case. So it's really helpful to you and on your funds if you prepare some of these and organize them in advance and label them well. If you send me 10 documents that are labeled with a series of numbers and letters, but those 10 documents represent 10 statements from a Wells Fargo account ranging from January of 2020 to October of 2020, then I am then, or my paralegal is then going to have to go into that document and then relabel each one of those to reflect what is contained in that document. So again, little things like that can really help you cut costs with any attorney. And I want to let you know that you want your attorney to be doing these things, because you might say, well, if I send you 10 different documents labeled with a series of letters and numbers, well, I still sent you the documents, you have what you need. But you want your attorney to be able to glance at that file and know exactly what's inside it. Otherwise, they're going to have to open that file every time it's referenced, every time they think they need information from it, every time someone asks it for something. You're going to have to open it up, sort through it to determine exactly what it is. So labeling it seems like a small thing, but when you're talking about digital documents, it can be time consuming. It's not as simple as writing number 1, number 2, number 3 on a piece of paper. It's very convenient and very handy and very time saving in the end to have digital documents, but it does require that you be able to organize them in a reasonable fashion and be able to organize them in a way that allows you to see clearly and at a glance if everything is included, and if not, what's missing. And not just what's missing, because over time, you have a requirement to supplement your documents. And so you may provide, as we discussed earlier, 3 months in the outset, but I am going to need to know 6 months down the line which 3 statements I'm missing. If I open up a case and see 3 documents with labels that I can't identify, then that could be any one of those 6 months. And those date ranges are important to me too. So I will tell you that when a statement is issued is not as important to me as when the statement period closed. So you receive a bank statement the following month after all of your transactions were conducted. What is really important to me is to know the date of the last transaction or the date that that period closes. And so again, if you label those documents in a way that allows us to see that quickly and at a glance, it will pay off in dividends at the end of your case. For post-decree issues, you're looking for different types of documents. They can interrelate, they can cross over, they don't always. Post-decree issues are generally going to relate to child support, possibly a maintenance that has already been ordered that has not been paid. Attorney fees are a really fascinating part of this analysis to me, because there are different statutory vehicles for receiving attorney's fees or for requesting attorney fees. But one of them is based on inequity of income between the parties or inequity of assets between the parties. And so although you might think initially that there's no reason that you should have to have mandatory disclosures in a type of proceeding that you are pursuing or are hailed into court for, it may be necessary that we complete those. And even if we do not have the mandate to turn those over to the other party, it might be very important that you provide those to us so that we have the type of defense that we need if this type of request is made by the other party. So here we have some helpful tips for going forward with this process. I think the first tip is actually really important. It's knowing in the outset that you're going to have to do this and that you really need to do it well and you need to do it thoroughly, and knowing that it isn't just a momentary issue and that it will not just benefit you in the moment. Keeping these documents in an organized fashion will serve you in an individual capacity as well as it will serve us in preparing and defending your case. If you cannot access a document, let us know. There are times when we can take actions to access documents that you're unable to access. Sometimes we can just help you, guide you through the process. We have a variety of different types of clients, as do all attorneys. So we have some very sophisticated clients who are familiar with using computer systems, databases and programs. And we have other clients who have really not had the necessity to spend a lot of time on the computers in their lives, who deal with paper documents generally, or who just aren't familiar with the ways or the ease with which some of these things can be accessed. So on a simple level, we can kind of help walk you through that, but on a more advanced level, there are tools that are available to us, subpoenas, for example, that can allow us to obtain documents. It's also true that there are times when a phone call from an attorney or a letter from an attorney can perhaps get something accomplished that would have been difficult otherwise. Save time by knowing what you do not need to provide. That is equally as important. Go work off of the checklist that we sent you. And if you need to, create an index on your checklist. Label your documents. Your documents don't have to be labeled in the way that I would label them, but if you find a way to identify them that allows you to determine whether or not you have provided that document, use it, do it. Make it anything that assists you in making certain that you have all 10 pages of the 10 pages that were contained in the document initially. Those will help you get through the process more quickly, and they will help us get through the process more quickly. If possible, send your documents to your attorney electronically. This really does go without saying. It increases the speed of the process dramatically. It increases the ease of the process. We will always accept physical documents at our firm, but we'll then have to convert those into digital documents. And that is a process that takes time. And as I say, we try to make this process as economically feasible as possible for you. I don't mind scanning documents. I don't mind labeling documents, nor do the paralegals at our firm or the legal assistants. However, we don't really like to have to charge you for time if you would have been happier spending the time yourself and saving yourself the money. Don't be shy about your debts and expenses. Debts and expenses and assets are such personal issues to people. In many ways, people treat these in the same nature that they would treat their relationship with religion or politics. They invoke a very emotional response. This is going to be the first time, perhaps in your life, that you're going to need to find a way to dissociate some of that emotion from obtaining, retaining, organizing, examining, and assessing these expenses, debts, and assets. I assure you, if you have more debts than assets, not only are you not the only one, you are in a sea of us, of people. So you should have no qualms in sharing that information with us. And further, we're going to take that information and try to use it to put you in the best financial place possible with your court proceeding or with the negotiations with the other party. I think that again, and I said this before, the best path is going to be to err on the side of disclosure. I am not going to give the opposing counsel a document that we don't have to disclose. I'm not going to give the other party a document that we don't have to disclose. Unless you and I have discussed it thoroughly, you have given your approval, and we have decided that there is a strategic reason to do so. But it is a lot easier for me to remove documents from a packet than to go seek documents from you. We are all a lot of my clients will be employed full time. It will be difficult. They might not be able to download documents during their workday. This may be something that they are only able to do in the evening. And just disclosing those in the outset will really help you, because you won't have to get those last minute phone calls or emails from us saying, okay, we're ready to move forward, but this is the issue that's holding us back. So I believe that concludes my discussion about mandatory financial disclosures. there are so many different issues that can come up in the process. So I'm certain that I have not talked about everything, but I do believe that it's really important to emphasize the value to you of full disclosure and providing these as quickly as possible. And if you have any questions, please let Sarah know and I'd be happy to answer them. Thank you. Sarah? Oh,
Thank you so much, Erin. Really appreciate that. So much information. We actually do have a question that came up a little bit earlier on in the presentation. So whoever asked the question, let me know if you need Erin to go back. But the question is, what if I cannot gather all the documents by the deadline?
Okay. So, and that can happen. So that's why it's so important to be communicating with your lawyer in the outset. So when you disclose what you have, make certain that you include, and I find it helpful. I'm always happy to take a phone call, to take an email. Any of those methods are great for getting information to me. But if you're putting together a packet, it's honestly pretty easy to take a blank piece of paper and write Belco account, account number, and you can put the end of your account number and then just write having difficulty obtaining this statement. And that can help in, like, as I said earlier, a couple of ways, because one, there might be methods that I can use to help assist you with that. Two, there are many times when one partner kept all of the documents in a relationship. So you may not have access to that because you might not, there may be a password on that account and you just don't know it. They may be physical statement. There may be physical statements that are being sent to that person. You're living in different places and you can't get to it. So those are issues that your attorney can really help you solve. And if you can't get it by the deadline, it is not, how shall I put this? It is not the end of the world. But what it will do is it will slow down the process. And that's why we like to know in advance so that we can do what we need to do. And again, if your partner has all of those statements, then often they're going to be providing them if it's a joint account, even sometimes if it's a separate account, but they have access to it, they may be providing that to us in their disclosures. And so I can let you know, look, don't hunt for that anymore. They just turned over all of those statements to me. And so we'll just include those same statements. They're on the same account in your packet. You'll disclose them back to them, or we can make a notation that says these documents are in possession of the other party. But unless we know in the beginning, we don't know how to address it so that your case is advanced in the time period that you would like.
Thank you, Erin. Another question. What if I have property or debts that weren't part of my marriage?
Yes, so that is a great question, and that's really important. And it's really important that we identify those as well, because what we want to do is make sure that we show and we are prepared to show why they're not a part of your marriage. What we don't want to happen is opposing counsel to come into court and say, oh, hey, they have, as I used cars as a reference, but any type of property, they have there's a house out there that's valued at $500,000 and we want half of that. And then as your attorney, if I haven't seen those documents in advance that say purchased on this date, and if I haven't seen the deed, if I haven't seen the title that shows whose name that property was titled in, where those funds came from, then I am not in a position to argue that on the spot in the way that I will be if you provide it all on the outset. And we're looking for that. We're looking for dates. When I look through your financial documents, I am always keeping in mind the date that that your marriage began as I'm looking at the documents. If they are near the date your marriage began, then I'm looking at things like where that down payment came from. So that's why they very well could be your own separate property, and I can't prove it unless I have access to it.
Thank you, Erin. Great questions, everyone. Just a reminder, I don't see anyone else adding questions, but if you do think of a question after this webinar, you can feel free to email us. I think Erin has had the contact information slide up. It's info@johnsonlgroup.com. You can also give us a call. We are happy to put you in contact with There it is. We're happy to put you in contact with any of our excellent attorneys, including Erin. So please feel free to reach out. Please ask questions. We are here for you. We're happy to help you through these difficult times. I don't see any more questions, but Erin, I will let you know if any come in via email. And thank you everyone for attending, and a big thank you to Erin for taking time out of your day for this. We really appreciate it.
Thank you so much, Sarah, and thank you for attending. Bye-bye.